and welcome to this edition of Legal Peppersoup. I am your host, Obi Wakeji. I am a legal practitioner qualified to practice in Nigeria and in the UK. I am also a musician and recording artist. In this episode, I'll be unpacking the massive legal war that's currently, I think, flying under the radar between Salt-N-Pepa and Universal Music Group regarding the ownership of the masters of their iconic recordings in 1986, which included the hits Push It and Showstopper. I'll be breaking down what UMG, Universal Music Group, I tend to call the master paradox, and looking at why the 35-year copyright safety net that is supposed to be applicable in the United States is suddenly failing legacy artists such as Salt-N-Pepa. So stick around. By the end of this day, you'll understand exactly how your master rights are being treated across 3 continents. I'll briefly look at the UK and I'll go a little bit more in depth in the position in Nigeria. And as a music creative, I think you will understand why your signature on a contract or an agreement is probably one of the most expensive things you own. Okay, so the asset at play here is the 1986 recordings that produced the debut studio album by Salt-N-Pepa called Hot, Cool and Vicious. It was a massive milestone in the music industry, becoming the first album by a female rap duo to achieve both gold and platinum status in the United States. Now, the album featured several major hits and included the influential tracks Push It and Showstopper. Now, in 2024, UMG actually removed many songs from the Salt-N-Pepa catalogue, including that 1986 album, because it was under dispute. And that's what the record companies or labels can do, because they have deep pockets and they can afford to not have the income for those particular tracks while they fight Salt-N-Pepa in court. As I said, the 3 tracks, Push It, Waterman and Showstopper, generated just under or approximately $1 million in 5 months. So you can imagine all the amount of lost revenue that Salt-N-Pepa are undergoing right now. And again, Universal is wielding and exercising the big stick to stick it to, pun, I don't know if that was intended or not, to Salt-N-Pepa for daring to challenge them in court. And that's why it's important to get your paperwork and your agreements properly looked at before you enter them, because if not, bad contracts allow these type of things to happen. Under Section 203 of the US Copyright Act 1976, artists hold a statutory termination right, and the goal is a second chance to own your own legacy. So after 35 years, after a copyright transfer, the original author can terminate the agreement and reclaim their master recordings. Okay, so we can see from this article from Music Business Worldwide, where UMG tells appeal court Salt-N-Pepa termination bid lacks legal foundation. Universal Music Group is pushing back against Salt-N-Pepa's attempt to reclaim ownership of their master recordings, telling the Federal Appeals Court that the duo's lawsuit has foundational deficiency. Now, the main issue is whether Salt-N-Pepa actually signed away their copyrights in the first place. Judge Coates in January found they did not. The decision centered on 3 agreements signed on May 15th, 1986. Salt-N-Pepa entered a recorded deal with Noise in the Attic Production, a company controlled by their producer, Herbie Lovebug Azor. The same day, Azor separately signed a distribution agreement with Next Plateau Records, which was later absolved by UMG, and the duo signed an inducement letter addressed to Next Plateau Records. Under the recording agreement, Nita held sole and exclusive ownership of the masters and their copyrights, and Azor then transferred those rights directly to Next Plateau. Judge Coates concluded in January it was only Azor and Nita that granted a transfer of rights in 1986 to Next Plateau Records, not Salt-N-Pepa themselves. Salt-N-Pepa appealed that decision, arguing the ruling contradicted Congress's stated intent to provide safeguards to artists. Now, when Salt-N-Pepa were teenagers starting out, right, they didn't directly deal with Next Plateau Records. Instead, they dealt with a production company called Noise in the Attic, which was owned by the producer and manager, Herbie Lovebug Azor. Now, Next Plateau's lawyers knew that they were buying their rights for Hot, Cool and Vicious from Herbie Azor's company, that's Noise in the Attic, not from the girls, not from Salt-N-Pepa. So to make sure the label was legally protected or bulletproof, Next Plateau Records drafted what's called an inducement letter and made Salt-N-Pepa sign it. Next Plateau's lawyers wrote the letter as a legal anchor. So they essentially said, we are paying Herbie Azor and Noise in the Attic for this music. But if the two girls, that's Salt-N-Pepa, get mad at Herbie and don't want to work for Noise in the Attic again, or if they break up or refuse to go into the studio, their investment is ruined. So that inducement letter was to ensure that the girls, Salt-N-Pepa, I keep calling them girls, but you know what I mean. They were girls at the time, teenagers, that they would fulfill the obligations that Noise in the Attic had with Next Plateau Records to deliver the album. So Universal Music Group are saying that that inducement letter was simply a sort of contract of employment, a guarantee of employment, making sure that Salt-N-Pepa just turned up. It was just like a work for hire. It wasn't anything, unusual. They just wanted to make sure that they turned up to record the album. However, Salt-N-Pepa's appellate lawyer, Richard Busch, is arguing that there's a specific line in that inducement letter. There's a line in there that says, we grant you all of the rights. And Busch is arguing that the label's own paperwork traps them because a label cannot demand rights from the girls, or the label could not demand rights from the girls unless those artists, Salt-N-Pepa, had those rights to begin with. So it wasn't the case. If they're saying that Salt-N-Pepa had no rights at all and the rights belonged to Noise in the Attic, Herbie Azor, why did the inducement letter say that Salt-N-Pepa were granting them rights? Okay, I'm just going to break down the global context of this and see how these kind of rights change from country to country. So in the United States, if you go to a studio and you record music and sign over your copyrights to a label, after 35 years, you can invoke Section 203 of the Copyright Act and ask for your copyrights back. The main thing, though, is if it's a work for hire in which the studio call you or the production company calls you and says, look, we're paying you this flat fee and you're just going to do these songs for us and we're going to pay you for it. We're going to take your copyright for it. It's just a work for hire. You're just here to do this job. Then there's no transfer of rights. You can't, after 35 years, come back and say, I want my copyright. In the United Kingdom, under the Copyright Designs and Patents Act 1988, the definition of an author is defined under Section 9(2), subparagraph AA, specifies that for sound recordings, the author is the producer. The CDPA contains no equivalent of the 35-year clawback unless an artist proves that they made the technical arrangements for the recording. They have no inherent right to claim ownership. So if you're in the UK and you go to a studio and you've composed your song, you want to now put it into the tangible form, make it into sound recording, that recording you make in the studio belongs to the producer, unless you have an agreement with that producer that he will transfer the rights of that sound recording to you. But the default position is that you do not own that copyright. So bear that in mind when you're recording or going to a studio. That's a conversation you'll have to have with the producer. The producer will normally or usually take a percentage of the sound recording or its fee to grant you 100% of those royalties, of the rights. But it's a conversation you have to know, and it's something that is important because all these things, again, are well and good when, the song has 10 streams on YouTube and on Spotify, 100 streams, nobody cares. But if suddenly it's picked up by, the sync deal or goes viral and all of a sudden you've got 5 million, 10 million views and all that, then you'll see that all of a sudden the fact that you haven't tidied up your paperwork will leave you at a severe disadvantage. So it's important that these discussions, no matter how difficult or awkward they may be, that they do come up and you start getting used to the paperwork tied with your songs. Remember, everything that you produce is intellectual property. It has value. Now, let's look at it from the Nigerian perspective. Now, in Nigeria, there is a system called Equitable Remuneration under the Nigerian Copyright Act 2022, under Section 15 and 37. There's a radical shift, moving away from asset reclamation towards guaranteed compensation. The bypass effect: even if a label retains pure ownership of the copyright, the performer and owner retain an inherent, continuous statutory right to a fair share of broadcast and exploitation income. So as you can see, under Section 15.1, there's the right to split income. You hold a statutory right to equitable remuneration, even if the copyright is transferred to a label. Performers and original owners retain a mandatory right to a share of ongoing income generated from commercial broadcasts and exploitation. Under 15.8, there's the right to information. So transparency is legally guaranteed. You have the absolute right to access all log statements and granular data relating to the broadcast and commercial use of your sound recordings to verify your compensation. And the assumption is that there'll be a 50-50 split on the Section 15.4. And there's a built-in safety net that if no specific agreement exists regarding the distribution of remuneration between the performer and the copyright owner, the NCC determines the split, operating on the default equitable principle. So what can you do if there's a dispute? Now, you should have an entertainment lawyer issue a formal demand letter to the record label under Section 15.8. Demand a full accounting of the statement, streaming logs, and exploitation data for the sound recording, alongside a demand for your equitable share of the revenue. You can also utilize a collective management organization, a CMO. In Nigeria, neighboring rights and performance royalties are heavily managed by CMOs, such as the Musical Copyright Society Nigeria, MCSN. If you're registered with them as a performer on that track, they can act on your behalf and to demand and collect those royalties from the users, or track down the distributors. Further step you can take: you don't have to, jump straight into expensive courtroom battle. You can file a complaint with the Nigerian Copyright Commission and initiate what's called the Dispute Resolution Panel. The Copyright Act 2022 empowers the Nigerian Copyright Commission to resolve these exact issues. As you can see in Section 15.3 and 15.4 of the Act, if the parties fail to reach an agreement on remuneration or how it should be split, it shall be determined by the Commission. The NCC has a dedicated dispute resolution panel set up specifically to arbitrate disputes regarding loyalty, splits, licensing, without the heavy delays of regular federal courts. If mediation fails or the label refuses to comply with a NCC directive, an infringement of a performance rights is actionable as a breach of statutory duty. Your lawyer can sue the label in the Federal High Court for damages, an injunction, an account of profits, forcing them to hand over the money they have made off your voice. So what you need to do is to check now, is to check whether you have a written contract with your label or production agreement. Was it an informal session? If it was, please try and work out your chain of title or work out what your agreement is with them. You might want to register with a collective management organization such as MCSN, because that could be the quickest path to your money. So circling back to the Salt-N-Pepa case, the Second Circuit Court of Appeals is expected to schedule oral arguments late this summer or in autumn of 2026. After that, the judges take 3 to 6 months to decide. This means we will see a final ruling probably late 2026 or early 2027. The stakes are massive. If Salt-N-Pepa wins, the case goes to a full trial and could trigger a global audit of old record deals. But if they lose, path to reclaiming their masters through the courts is completely dead, and they'll probably have to enter into a private settlement to get their music back. We will be watching closely. I am Obi Wakeji signing out for Legal Peppersoup, and I'll see you in the next one.